She has an open case upstairs that's
From the very start, this hearing sets a serious tone. The defendant isn't just facing one charge, she's juggling multiple open cases, including one involving a child injury. In the courtroom world, that's not just a red flag. It's a legal fire alarm. The judge's first words already tell us, this won't be an easy bond discussion.
also in warrant status. Frank has been talking with Judge Nelson in the
May I have the case number, please?
252 1200.
Okay.
So because she has a felony warrant, I'm not going to release her. We'll do PC now, and I'm going to keep her, and then Frank's going to run up to the 482nd to try to get her a bond set there.
It looks like probable cause was found on July 25th, Judge.
I'd like to know, but I don't know. All I know is that she's charged with assault. She also has an injury to a child. It looks like they're out of the same transaction.
Yes, Judge.
You're facing up to a year in jail and or a $4,000 fine on the assault. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you then.
On June 24, 2024, officer with multiple complainants, and one of the complainant's mother, Dr. Clinton, this case investigated an assault that occurred in an apartment complex. Complaint stated that on Wednesday, June 5th, 2024, this complainant, part A, the complaint that they met, the brother is a complainant in this offense who's 15, and his friends were walking their dog, encountered a juvenile male, who's the son of the defendant, over problems they had in school. Juvenile male's mother, the defendant, exited her apartment unit, started to confront the complainant and followed co-complainant and this complainant to a fence. The other complainant felt the need to defend himself due to the now defendant being close to him, but he did not assault the defendant. Defendant pepper sprayed that defendant and that complainant, this complainant, attempting to get her to stop by swinging at her. Defendant also pepper sprayed, pepper sprayed this complainant, but only hit one of his arms. The other complainant felt pain from being pepper sprayed by the now defendant, and the first complainant, the mother of the other complainant, wanted to pursue charges. A witness who lived in the apartment complex corroborated the statements of all the complainants.
So who are the complainants now?
So
Relation?
it is brother complainants and their mom, who is another complainant, but I don't know if they.
So it's familial.
I think it's the two boys, the complainants, but one of them's 15 and older.
So they wrote it as complainants, but it only accepted charges. So I guess the way they verbalized it initially to the officers, the way they wrote it down was complainant 1, 2, and 3, or
Okay.
complainant 2's mother, complainant 1. So formally, in terms of the charges, there is the complainant upstairs for injury to child, and then this complainant is 15, which is why it's right above the felony level. But they wrote the mother as complainant, I guess, to the surface.
Ours is
But the complainant here is a 15-year-old.
no familial relation.
No.
No, it's just that their brothers and friends encountered the juvenile male, the son of the now defendant, over problems they had in school. So it seems like there was a schoolmate issue.
Okay. Ma'am, did you want to say something? I'm sorry.
I mean, I know that we'll fight the facts in the future, but she takes care of 3 children. The son that they're talking about, the son's 12 years old. Looks like there was some argument between these kids, and just to make her point of view, she was trying to speak with the complaining witness's mother regarding this whole situation. Looks like it got out of hand. I do have a picture from the defendant regarding an injury that she received from a busted lip of that day from the juvenile. Moving forward, I would like to set a bond, at least at the minimum of $1,000, and it'd be a PR bond.
State of Texas.
Judge, I just need seconds. I was trying to look up something else that wasn't popping up. Your Honor, state requests that reasonable bail be set because this is not the only complainant involved. Obviously, there's the felony as well, and the fact that she has been charged prior for a disorderly conduct with a deadly weapon, assault family member.
The injury to a child, it's what, 14, right? 14 and under?
Yes, and the other complainant was 12. So that's why there's a felony and a misdemeanor and the fact that another adult person involved and there was a witness is that
Shh.
allegation still resolved. And so state requests reasonable bail be set at 7,500.
Family violence was dismissed, Judge. The only conviction I see is theft.
Yeah,
from
I mean, I see
2009.
two dismissed, I see dismissed it orderly. Do you have any like out of state or anything else?
When the, I don't believe it's,
Okay, well,
it's not enough for me to impact my,
right.
oh no, it's down here, never mind.
This is classic Judge Fleischer, firm, fearless, and laser-focused on community safety. Notice his tone. He's granting freedom with a warning. What do you think, though? Is the $1,000 bond fair considering her history? Or is the judge showing mercy here? Let me know in the comments, because this one's tricky.
Sorry, they're all in, but
So it looks like the only possible conviction that I see is a theft from '09.
yes, Judge.
And the other two cases,
The only bond forfeiture is very,
okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm going to set your bond at $1,000 now. We'll give you a PR bond now, but I'm not going to play this game. I'm going to protect everyone in my community at all costs. I don't care who you are, where you come from, doesn't matter. You understand? As part of your bond conditions, you're not to have any contact with the complaining witness in this case and not to be in possession of any weapons as well. Weapons is a very loose term. So if you have any questions, talk to Frank because no weapons whatsoever. I'm also ordering you not to go where they live or where they work as well, man.
I do have a concern about that because do they live in the same apartment complex or is it a different?
it was the children that are schoolmates, so I don't think there's otherwise, but not that I could find. I'll take a closer.
They were just roaming around.
Her head, so I don't believe that'll be an issue.
And so you're okay. I'm going to attach you to this as well. I'm going to go ahead and email Judge Nelson.
It's the ADA on record. I'm just helping out since we're shorthanded and but I'm not opposed.
Okay, I have emailed you guys and I CC'd you guys. I've also talked to her. Would you please take a seat in the jury box? Do not leave until we have you sign bond conditions and then until Frank gets back to talk about the bond. Okay?
Thank you, Judge.
No, ma'am. Jury box. Hey,
Judge?
come on up. Yes, sir.
Daryl Bohana, Your Honor.
What's the last name?
Bohana?
Bohana. Okay. This is the person that got out of ICE custody, right?
No, Your Honor, this is another individual. We came in November for the arraignment setting, and he was a truck driver, Your Honor, a commercial driver, and you put a restriction because he was actually had an alcoholic beverage allegedly in his possession at the time, so that he could not drive. So you informed me that if he abides by his conditions, that you would give him the opportunity to perhaps have some sort of device, either to his vehicle or a portable scram.
Is he here?
Yes, sir.
Mr. Bohana.
So that he can get back to work. How are your holidays, Judge?
Are you
It was good, yeah.
getting ready for the freeze?
Oh, yeah, we'll see. I mean, I'm supposed to have a jury trial on the 21st, so we'll see if that goes.
I don't know. Bringing all those jurors down here with all that women.
Yeah, I'm not sure, because, accusing gets a little skittish with cold weather. They shut everything down.
Good morning, Mr. Bohana. The only thing that I'm trying to impart to you is that it's a privilege. It's not a right. Driving, it's just a privilege. You want the right, you can walk. Otherwise, it's just a privilege. And it's just elementary that you're not supposed to do certain things in life. What I'm trying to do is trying to get you just to appreciate the awesome privilege it is to drive. Do you understand? So he drives trucks for a living. How are we going to do it?
Well, Your Honor, I believe, I'm not sure if you would think that a portable was acceptable, but if a portable wasn't acceptable, I would recommend a scram device, Your Honor.
So what I'm gonna do is, do you drive 18-wheelers?
Not sure, Mr.
Yes, sir.
Can you put a device on an 18-wheeler?
Not the companies, but I drive for a company.
So you're driving a company vehicle, not yours.
No.
You don't own the vehicle.
No, not a truck, no.
Okay, so what I'll do is, he'll have a device on his personal vehicle, okay? And then we'll put a scram on him and I'll allow him to drive the work vehicle, but the scram will tell me at all times whether he's consuming anything. I'm putting a device on your ankle to measure whether you're consuming any kind of alcohol. Don't. Anything you put in your body, make sure you know what it is, because if there's any doubt, don't put it in your body. You know, Listerine, mouthwash, whatever it may be. Certain things may have alcohol. Certain fruits ferment, turn into alcohol. So you need to be aware of these things. Know what you put in your body, because if I find any kind of alcohol consumption, I'm going to take it away again. You understand?
Okay.
Okay. All right.
Your Honor, and I'm sorry, Judge.
Go ahead.
Mr. Rohana has been attending a couple AA meetings, just for the knowledge of the court. He's trying to learn how to better handle alcohol problems. He hasn't been working since November. I'm not sure how much he has saved up. I haven't
I'm going to pay
discussed-
for it.
Oh, okay.
I
Thank you,
always
Judge.
pay for everything.
Okay.
Don't worry about it. Money should never be an issue. I
Thank
pay
you.
for everything for everyone, so it doesn't matter. So scram, and then, well, he's here now. We might as well get it here because this is where we get it, right? And then the interlock within 7 days, and then waive the fee for both, please. Okay.
And we're still waiting on body cams and station videos on this case, Your Honor. It's
72
pretty
days, doesn't matter.
If it's uploaded, I'll double check, but there are videos that were just shared with you.
Okay,
Yeah.
he just shared it. Thank you,
Okay,
Judge.
guys, take care.
Thank you.
All right.
See you, Your Honor.
Safe. Good morning, Mr. Asanga.
Morning, Your Honor.
Sir, you are wanted out of, you say Fayette,
Yes, Your Honor, Kentucky.
from Kentucky for theft by deception of up to $10,000. Your lawyer has asked for me to set you a bond, and I'm going to tell you now that we don't set many bond in fugitive cases because you are an inherent flight risk, right? You're wanted from a different state, and we're putting a lot of trust that you're actually going to go back. You're old enough to know that actions have consequences, right? I'm going to set you a bond today because they're not opposed to it. She's asked for a $1,500 bond. The state's asking for a $5,000 bond. I'll set your bond at $2,500. Because it's a fugitive case, typically you'll have to make all of it. They don't usually do the 10% because, you know, you're a flight risk. So the thing that you need to understand also is that I'm only going to do this one time. I'm not going to do this again. I will give you one bond. And what we do is we give you 2 weeks from the date of your release to go turn yourself into Kentucky. If you do, and you get the proof to Ms. Morgan here, they'll dismiss this fugitive case against you. If you fail to go, you got to know that there's a consequence, and the consequence is huge because I will revoke the $2,500 bond. I'm going to set it at 0, and I'm going to issue a nationwide warrant for your arrest, and I'm not going to do this again. I'll get you eventually, and this time I'm going to hold you until Kentucky comes and gets you. Do you understand?
I understand, yes, Your Honor, but the only problem I might have is with the full amount, paying the full.
This is not a negotiation, right? I'm going to tell you that $2,500 is a very low bond for a fugitive case as it is. So I can tell you probably on one hand how many times I've set a bond at that amount or even lower. So the other thing you need to understand, Mr. Asanga, is that for you to post bond, you have to withdraw any waivers that you've made. Did he waive? Ms. Morgan, did he waive? It's not. Okay, so it's a non-issue then. I don't need you to make a decision now what you want to do. If you want to waive extradition, we give Kentucky 14 days to come get you. If they don't come get you within that time, Harris County releases you. I'll give you time to talk to Ms. Morgan to tell us what you want to do, whether you want to waive, whether you want to try to make bond. It's up to you.
I'd like to make a bond.
Okay, so I guess
The reset then, last date is the 30th. Well, the 30th would be court date, but the morning of, check if we haven't heard back first.
what I would suggest is probably not setting it off 2 weeks, just in case that there's an issue. I mean, if you definitively know someone's going to post a bond, then go for the 2 week, you know? But if you've spoken to family and they're having trouble, then just do it you know, right, so that we didn't sit
I
there
might
for
be
2
out of
weeks.
town that week, Your Honor, so I would approach sooner.
I Zoom. That's why I have it, so you can always, I mean, we've had people come in bathing suits, you know. So, okay, all right. Good luck to you, sir.
Thank you, Your Honor.
Is one of them yours? Let's do it together.
You ready?
Yeah, come on, come on.
Oh,
Bring it.
okay. I didn't know.
It's deficient. Take your time.
Y van a contestar a voz alta, no puedo interpretar.
We're Mr. Gil Rodriguez,
Rodriguez?
and you are Mr. Ventura.
Ventura?
Sit.
Yes.
Both of you
Los
have
dos
picked
de
up
ustedes
criminal
tienen
cases.
delitos criminales.
Both of you have
Los
worked
dos
out agreements
han
with
llegado
the
a un
state of
acuerdo con el
Texas.
estado de Texas.
You need to understand that the agreements that you guys are working out today will reflect as convictions on your record.
Sus convicciones
Once you plead guilty, there's no turning back. It will go on your record
van a estar,
and it will be there for the rest of your life.
estar allí para todo.
You give up many valuable rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. And like I told you earlier,
Las leyes federales, como les
once you
dije,
plead,
bueno, al
it's there
declararse,
forever. It's even there after you die. You can never take it off. Mr. Gil Rodriguez, you are charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine.
$1,000
The agreement you've worked is 7 days in jail. Credit for the 7 days that you've done. Is this how you understand it?
I understand guilty.
All right, I'm going to find you guilty. I will follow the agreement, send you to it. I'm going to tell you now
Voy a
that
decir ahorita,
any more cases you pick up, you will be facing a minimum of 90 days in jail. No more proverbial slaps on the wrist.
no los vamos a dar.
Mr. Ventura Lopez, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine, and you've worked out an agreement where they're offering you 6 days in jail with credit for the 2 that you've done. Understand, by pleading guilty to this offense from now on, you will be facing a minimum of 30 days in jail.
30.
You understand?
Yes.
This is what you want to do.
Lo que usted- Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Hablo no culpable. Guilty.
I'm going to find you guilty, sentence you to the agreement.
¿Al acuerdo?
I'm going to tell you now, anytime you get pulled over, officers will look at your record. They're going to see that you have a prior DWI. If they come up to your car, they smell alcohol on you, it's probably not going to go well.
No le va a ir.
If I were you, for the rest of your life, if you want to get lit, don't get into a car
No se meta un auto.
because it's a humongous gamble. I'm suspending your license for 90 days. Do not drive until you get a license.
Tenga una licencia de conducir.
Yeah, you're appointed on the case?
I am, Judge.
Okay. I'm going to tell you one more thing, that DWI is big business in Texas. There is a $3,000 surcharge that normally we would tack onto this. On a second DWI, it is a $6,000 surcharge that you can look forward to on another one. So be careful. Don't come back.
Y no
All
regrese.
right.
Thank you, Judge.
Yeah. All right. Good luck, guys.
Are you waiting the surcharge? Oh, thank you,
No le van a
Judge.
cobrar los 3,000. ¿Tiene gracias?
Do I know you? I mean,
Le van a cobrar los $3,000.
gentlemen, that way. Holy moly. Wow.
I'm
Hey, great to see you.
good to see you, Judge. I'm here on Amanda Hale.
Let me see. With an H, right?
Yes, Judge.
I don't see it. Oh, she in custody?
Yeah, it's on a fugitive docket.
Oh, fugitive. Okay.
She is wanted out of Hines County. She has a pending case in the 182nd. She is asking for a bond to be set. She wants to go to Hines County and handle it herself. She stated that she has attempted to do so, but was told that her bonding agent quit 2 years ago. And in the interim period, she got arrested on this.
We have not made bond on the felony case yet.
That is correct, Judge.
Do you know if she's going to?
She said that she was.
Okay. Great state of Texas.
Sorry, I just want to check one quick thing before regarding that. Oh, yeah, it looks,
I don't even know what the charge is.
oh, it's
I guess-
burglary, Your Honor. State would be opposed to bond. The fact that, number one, that she hasn't yet made the bond, but it had been set for 10,000.
But the problem is like a lot of times, you know, it really doesn't tell me much because a lot of times they'll go try to bond out, but they're unable to because a particular bonding company says, oh, well, you got a fugitive case, you can't get out anyways. So the fact that they haven't made bond doesn't really tell me anything because I don't know if they tried and were denied, you know?
Yes, George.
So
So she does have some history. She was recently convicted in Galveston for a deadly weapon that was originally charged as aggravated assault with a deadly weapon. And was burglary habitation was dismissed pursuant to that plea.
oof,
She also has had some history in that same. She was charged previously as a fugitive, but in openness, it was a lot older. But she has had a prior fugitive case in '95. She also had a prior larceny charge, 2 prior larceny charges, and a grand larceny charge. So state would be opposed.
I do, it's gonna be high.
I understand, Judge.
I mean, it's gonna be like,
Oh, sorry. And this warrant has also been active for a hair over a year, possibly longer, but it says date of warrant issued out. It's like January.
do you know if she took flight?
For that, I wouldn't be able to say, but it was in.
Can you
well,
find out?
Technically, yes, because she was charged with UUMV for the pendency of the warrant. So I don't know why they didn't place it when she was originally arrested for the UUMV in the 180th, because that's since been dismissed. But my point is, when she was originally arrested, I don't know why they didn't.
Yeah, I don't know, Shalom. I mean, it's just way too much. She got an ag assault over there. And you said that's recent too?
That was last year. It was a conviction, but it was pled down to deadly conduct. So it was originally charged with ag assault and burg hab, but then pled down. It
Like,
was
how long ago?
September 2024 was the conviction, I think. But let me double check. I don't want to misspeak.
So she picks a UMV here.
The conviction was, oh no, sorry, July 3rd, 2024. My mistake. So July 3rd, not September 3rd. So. Then also a PCS, but that was dismissed. March of June. In Galveston, not here. Well, on top.
UUMB dismissed.
I'm sorry?
It was UUMB warrants. Found no PC. It's gonna be high. I mean, if I said it's probably like north of 20, you know, and she's gonna have to make all of it, you know. So I guess let her know if she's amiable. Has she waived already?
She's waived already.
She can, if she wants it, she's gonna have to do the waiver withdrawal. She'll lose all that.
Hello, Judge.
Absolutely. Yeah. Do you mind bringing out Miss Hale, please?
Mine is easy, Your Honor. I'm
Tell
just
me.
asking for a reset on the gentleman I'm having court here today.
Is it old?
190 days.
Oh,
It's 190 days. I'm just setting it for a plea.
okay. You got it.
Thanks,
No.
Judge.
That way, when they hear it from your mouth, Judge,
That's okay.
it's like I didn't sell them a wolf ticket. I don't know what it's called.
What about the song that fugitive guy?
We're waiting on them to, I don't know if they're, oh. So do you want me to set the bond at 2,500 for Asanga?
And just when you think things are cooling down, boom, another fugitive case hits the docket. This time, the judge faces a bigger question. Can you trust someone wanted in another state to show up in court? The stakes rise fast here, and the judge's patience starts running thin.
Did we confirm?
Oh, no, we'll meet her back from Stacy. She went in the holdover.
What do you want? Oh.
So he said it at,
Yes. Okay. Yeah, that's fine.
let me make it. Good morning, ma'am.
Morning.
Shh. You are wanted out of the state of
Mississippi.
For a burglary, Your Honor.
for a burglary charge. Your lawyer is asking me to set you a bond. I don't know. You know, one of the main things are you a danger to my community? Because if you are, it's just not going to happen. I'm going to do everything in my power to protect my community at all costs. You know, I have a lot of people that tell me, you know, little bunnies jumping in the woods, that's who they are. But when I look on paper, they're a completely different person. Mr. Kim, would you mind telling us about Ms. Hale, please?
Yes, Your Honor. She's currently also being held in the 182nd for second-degree level of possession of a controlled substance. She was recently convicted in Galveston County for a deadly conduct charge that was initially pled as an aggravated assault with a deadly weapon, along with a burglary habitation that was dismissed presumably with a plea deal. She was also previously charged with possession of a controlled substance that was dismissed earlier last year as well. She was previously a fugitive, charged as a fugitive in the 90s, along with a few other charges from Mississippi, 2 charges of larceny, 1 charge of grand larceny, and obviously these offenses.
Yeah, I don't, it's too much baggage, man, you know, and especially you also telling me that this case is over a year old.
For the warrant, that one was issued out on January 10th, 2024, Judge. So it's been 1 year.
Do we know if she knew about it?
That I wouldn't be able to say. I don't know if it's an FTA, Judge. I can find out, but I don't know the answer to that point. It typically says, it just doesn't say.
Here's the deal. If I were to set you a bond, you would have to make, I think you would have to make all of it. It's not something where you can pay the customary 10% because you're an inherent flight risk and you have a prior fugitive case as well. You know, I don't think, I'm not going to set you a bond, man. You just got way too much baggage. You have a prior failure to appear. This case is a year old. You've got a second-degree felony. Is it with intent to deliver?
No, Your Honor, it's just the amount for
Yeah, it's just too much, ma'am. I'm sorry. So the deal is this, is that you have 2 choices now. You can waive extradition, which in this case, normally what happens is we give the other jurisdiction 14 days to come get you. And if they don't come get you, Harris County releases the whole. But for that to happen, you have to make bond on the felony case. Because you have not made bond on that case there, it's kind of in a holding pattern until you either take care of that case or you post bond on that case. If you post bond on it, that will get the 14 days to start kicking. Okay?
She's already signed a waiver, Judge.
Oh, she's waiting.
Under the Met.
Oh, okay.
Already, Judge.
Got it. Okay. But just to give you information, I don't know how much you know or not, but right now we're basically in a holding pattern anyways, just because you've not made bond on that case. Okay? If you don't understand, I can have Shelby tell you more about it so that you can get a good grasp on what everything is. But understand, it's just too much baggage, man. Okay? All right. Thanks. Thank you. Good morning, ma'am. Ms. Ambrise Villarreal, you were charged with theft by check. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On August 27th, 2024, the defendant issued a check to the Harris County Tax Assessor's Office in the amount of $174.25 as payment for 1 vehicle registration and a vehicle registration sticker. The bank returned the check marked insufficient funds, and the complainant has provided a copy of the demand letter to the defendant via first-class mail with the affidavit of service attached. The letter was not responded to.
All right. Ma'am, I'm going to find that there's probable cause to go forward with your case. Do you have a lawyer today? Do you speak English?
Yeah.
Did you want to apply for an appointed lawyer, ma'am? Okay. Let me see if I have one on file. I don't have one on file. I'll give you an application. If you qualify, I'll provide your lawyer today. I'll have you sign a reset with Victoria and then we'll have you fill it out, ma'am. I don't want you to say nothing. Please, everything you say, they can use against you to prove guilt, and just when we give you a lawyer, you can talk to the lawyer. Okay? Please.
Judge, any conditions or no? Yes, Judge.
No condition.
Judge, on Mr. Fox, the state's currently talking to felony to make sure that they're authorized to do that time served. Would you be willing to terminate his probation case, his criminal mischief deferred? Or would you?
You guys think that's appropriate? What do you think on Mr. Fox?
That he does have an open MAJ, and so we could either time serve him along with the DWI, unless we coordinate with the felony, or really whatever the court, feels.
Doesn't matter to me. I mean, I didn't want to even take anything because I think he needs to go to treatment, but our hands are really tied because of Fort Bend. Can't do anything.
It may even give him treatment once the holds are done here, Judge. I don't know, but it's sort of like, we can't give him treatment because of those cases. They can't give him treatment because of these cases. And so.
We also have a pending evading and felony court, Your Honor, and so one of the things that we're interfacing with felony is, if they were to put him on probation, can they do DWI style
Yes,
condition?
that would be
That would be-
fantastic.
I think in a world of sunshine, where everything goes the way we would like, he would go up to felony, get a treatment plan up there, and then hopefully Fort Bend feels that he's been sufficiently treated here with a conviction for DWI, conviction for the MAJ, and then his treatment terms, if that's what they decide to do up there, here, that they don't feel like they need to pursue their case and that whole
Let's do
gets
that.
released. So in a world where everything goes,
So
I would like it to go.
let's do that. Let's see if we can work a global for everything, and because he's here anyways, I guess. Music has felony.
Got him
court.
here today, and do you represent him in felony? or
I
is
do
that
not,
somebody
and
else?
and he told me that he's talking to his attorney there about seeing if it can be reduced to a misdemeanor. I don't know if they're willing to do that for a misdemeanor deferred. Well, Judge, I just don't know.
So let's do this. You still have to get the okay from upstairs or what?
I'm just waiting to hear back from them, and then if we don't hear back, I'll just run up there and go talk to them.
No, you don't have to do all that. I mean,
Fine.
really, if
I
you
don't know how
want
to
to,
use the computer, so I'm pretty useless. I'm running up and down the stairs is the thing I can do.
like a day or so just to figure it out, I'm okay with that. If you get the approval now, then we can do it as well.
We just don't want him to get a long reset.
I was hoping that we could do like,
And
yeah, I was hoping we could do a global so that everything takes care of,
Well,
but-
part of it is, I think, he's been motivated to not work out his felony because he's stuck in here anyway. So I think that.
I'm willing to work it out
Right.
because I know that Fort Bend really ties us up and, I wanted to put him in treatment. Ever since day one, they said, we had him TRAS to say, put him in treatment. And I was convinced not to. And then he ends up picking 3 other cases up.
we'll coordinate with felony to see what they're case and what they are planning to offer.
Yeah, okay.
And then,
Yeah, I'm down with whatever.
we can
Sure. So
coordinate with his defense attorney up there.
if we don't hear back today, just roll it to maybe a day or?
Day or 2 or
Okay.
whatever. Yeah.
All right. Sounds good.
Is he even here?
No, he's here, Judge. I've been talking to him back there. Okay. All right. Thank you, Judge.
Thanks, Your Honor.